Good morning. The Rehabilitation and Social Services Committee will now come to order. Thank you to those in the audience for joining us and to those on Zoom who may be watching or watching us virtually online. I am going to ask the clerk to open the roll so we can determine if we have a quorum.
You have a quorum, Madam Chair.
Thank you. Okay, colleagues, I have a housekeeping item. I would like a motion to re-refer Senate Bill 1379, Senator Deed's bill, to the Judiciary Committee.
Second.
Okay, a motion has been made and seconded. Will the clerk please open the roll?
Ayes 11, no 0.
Okay, thank you, colleagues. That bill's been re-referred. I don't see any senators in the committee, not on the committee, in the audience. Let's go to, I'm going to do Senator Pillion and then Senator Mason until another senator off the committee comes. Senator Pillion, good morning.
Good morning, Madam Chair. Now, that's now Aaron Rouse. So 1421 is a bill that amends the process by which local law enforcement is notified about adult protective services. Currently, there's a 24-hour hotline that's responsible for making those referrals to local law enforcement of suspected exploitation, injury, and neglect. But while the APS hotline report they're electronically submitted to the local DSS office, hotline staff frequently have difficulty finding local law enforcement contact to receive the information when it ties up the process, creates a backlog. So what we decided to do is make the adult protective services just like the child protective services and take away the hotline. So there's somebody from here that can talk about it and explain it better than I can, but come on further.
I think we understand.
You do,
Do you have
yeah.
a speaker? Come forward. You're speaking in favor?
Hi, Madam Chair. I'm Paige McCleary from the Adult Protective Services Division.
Okay.
At Department for Aging and Rehabilitative Services. I was just available if you all had any
As a resource.
questions. The governor supports this legislation.
Is there anything more you'd like to add to the description of the bill?
I think he did a fine job, but I'm happy to answer any questions that you have.
Okay. Is there anybody in the audience who wishes to speak in favor of the bill? Anybody wishing to speak in opposition?
Madam Chair.
Senator McPike.
Thank you, Madam Chair. Can you help explain better what the problem is that we're facing with
A backlog. But
Yeah.
the data associated with climate change?
So several years ago, the hotline was tasked with referring certain factors. So not every APS report that comes in requires law enforcement intervention. So there's certain factors when the report comes in to the hotline that trigger a report to law enforcement. The report still goes to the local Department of Social Services for investigation. But when the hotline, one of those factors is present in the APS report, that hotline worker has to step off the phone and try to locate a law enforcement official in the various, hundreds of jurisdictions to actually receive that information. And what has happened over the years is as more factors have been added in, particularly with the financial exploitation component, there's more requirement for the local law enforcement to be notified. So they're actually stepping off the phone. The calls to make a report to the APS hotline are backing up, and callers are waiting in a queue as that person is trying to locate a law enforcement official to take that report. Essentially what we're doing is just mirroring CPS requirements and having the electronically, the report is sent to the local department, and the local department will then be responsible for making that report to their local law enforcement official. So instead of having the hotline trying to find the proper person for all of Virginia to receive that report, it'll just be transferred the authority to do that to the local department. They're making reports anyway. If the report comes into the local Department of Social Services directly, those folks are making those calls to local law enforcement anyway.
Madam Chair, just one follow-up.
Senator McPike?
So instead of a hotline, it's just the main, the mic hotline. So instead of the call going to a hotline, it just goes to whatever main line, or is it 24-hour line still at the local department?
So so are you saying any report that comes into the APS hotline, it's a 24-hour operating hotline where they're still going to receive all of the APS reports and then refer them to the local department. The local department is sent electronically through our case management system and received by the local department. They open it up and evaluate the report and make the necessary referrals.
One more follow-up.
Yeah, sure, Senator McPike.
I'm just trying to work
Sure,
through.
that's fine.
Each local department still has a 24-hour hotline, or not hotline.
They have staff.
It's staff. It's not a hotline, but it's still staff.
Yes, there's staff.
If this call's still coming in, is it a staffing issue or a really hotline issue? I'm just trying to understand the workflow. If the same person is still just not on the hotline, but on a department line, how does this change anything?
So the call that's coming into the hotline is operated, this is the state hotline that's operated at the Department of Social Services.
So it's all just going local, on the local report only?
So the hotline is mandated to, refer all reports to the local Department of Social Services for evaluation. They don't validate reports. They just send the information to the local department. The local department will then evaluate when they receive that report, whether or not it requires intervention by local law enforcement as well.
Any further questions, Senator McPike? Colleagues, do you have any questions while our resource person is here? I had already asked for comments, and we didn't see any from the audience. Is there anybody on Zoom who would like to speak to this bill?
Anyone on Zoom who would like to speak on the bill, you may raise your hand electronically. We have no speakers, Madam Chair.
Thank you. Okay, motion has been made to report and seconded. Will the clerk please open the roll?
Ayes 13, no 0, 1 abstention.
Okay. Your bill reports, Senator Pillion. Do you want to do 1424?
Yes, ma'am. So,
Okay.
Madam Chair, this is a simple bill. This bill authorizes staff, any staff designated by the DOC director to administer naloxone to offenders and probationers. Currently, the code only allows probation officers and correction officers to carry naloxone, and this would allow any employee in the DOC to administer and carry it.
And they would be trained, I expect.
Yes, under current code, they would be trained,
They would.
yes.
Okay. Is there okay, colleagues, hold on a minute. Is there anybody in the audience who wishes to speak in favor of the bill? Please come forward.
Good morning, Madam Chair. Rose Durbin, Virginia Department of Corrections, and we support this bill.
Thank you. Is there anybody who wishes to speak in opposition? Is there anybody on Zoom who wishes to speak to the bill?
Anyone on Zoom who would like to speak on the bill, you may raise your hand. We have no speakers, Madam Chair.
Okay, looks like your bill is straightforward. We understand it, and we're ready for a motion.
Second.
Okay, will the clerk please open the roll?
I'm on the committee.
Who has Senator Hanger's proxy?
Ayes 14, no 0.
14-0. Senator Pillion, your bill reports. Okay, I'm going to take Senator Obenshain. Okay, Senator Obenshain, would you join us?
Thank you. Madam Chair, I have two bills. First is Senate Bill 1221, dealing with assisted living facilities. Committee understands that assisted living facilities provide care to vulnerable adults who do not require skilled assistance. Right now, and I'll tell you a quick story, I promise it'll be quick. There are assisted living facilities all over Virginia. Some are very, very small. There's one in Edinburgh, Virginia, little rural community. I guess about a year ago, resident there family-owned, family-run facility. Resident there was defiant, said, "I won't eat my lunch." The owner of the facility demanded that she eat her lunch, told her, "If you won't, you're going to your room." She said no. The owner then grabbed her by her hair, threw her out of the chair onto the floor, tried to drag her back to her room. In the process, broke her hip, left her on the floor overnight, told other staff, and there was only one other staff member there, told them, "You're going to leave her there because she's garbage, and that's where garbage stays." And nobody came in until the next morning. Called 911. She was emergently taken to hospital, was transported, had emergency surgery, repaired the hip, and the owner was ultimately prosecuted, and after a series of misadventures in which a deal was originally offered to let her plead guilty to disorderly conduct. She ultimately pled guilty to a felony, abuse and neglect of an incapacitated person. This family came to me as a lawyer, and I said, "Well, I'll represent you." Looked at the regs, and the regs say the minimum insurance shall be $250,000 for assisted living facilities. Said, "Thank God, that's great. It'll at least pay your medical bills." Only to find out that the minimum insurance is only applicable if the facility chooses to have insurance, okay? So the board says, if you have insurance, it's so important that you can't have less than $250,000 of insurance. But you can elect not to have any insurance. This facility has no insurance. This family, and she's on a grant program. She didn't have any two plug nickels to rub together. She was moved to Roanoke and is in a facility down there. This simply says that the insurance requirement's mandatory. And it says that the board shall establish the level of insurance. It's not mandating it. So I think there's a substitute, right, or an amendment.
I was going to say,
Madam Chair, I guess the mic's not working. We've got,
Mr. May,
it's not a substitute, but we've got two line amendments. Bear with me, I'm going to go ahead and offer them now.
please go ahead.
See them online. So, like I said, they're a little lengthy. The first is on line 84, after the stricken number 9. Insert, in establishing such minimum amount of liability insurance, the board shall consider the number of residents for which an assisted living facility is licensed and establish a minimum amount of liability insurance for the following tiers. Tier 1, which shall cover an assisted living facilities with no more than 25 residents. Tier 2 is more than 25 but less than 75. Tier 3 is more than 75 but less than 150, and Tier 4 would be over 150. And then the second line amendment is on line 154. It would insert a second enactment clause that would do two things. Direct the Board of Social Services to promulgate emergency regulations to implement the provisions of the bill. And it would also give an exemption to assisted living facilities from both the provisions of the bill and the new regulations for a period of 180 days after the regulations become effective, which I'm guessing is just giving them a little time to go ahead and secure that insurance policy.
move the amendments.
Okay, all those in favor of adopting the amendment signify by saying aye. Aye. Okay, the amended bill is before us. Senator Omochain, I expect you worked with stakeholder groups. There is an association of assisted living facilities.
I think Mr. Johnson is here, and yes, we have endeavored to, and I hope have been very cooperative in that effort. I just can't, I was thunderstruck when I found that there's no insurance required.
Yes, you gave quite a illustrative example. Mr. Johnson, let's bring Mr. Johnson forward, and then we'll take a question. Do you have a question, Senator Mason?
Good morning, Madam Chairman,
Good
members of the
morning.
committee. Scott Johnson for the Virginia Healthcare Association and Virginia Center for Assisted Living. Let me just say at the outset, we favor our members having liability insurance. Let me also thank Senator Obenshain for working with us on these two amendments. And I'm glad to answer any questions you may have if Senator Mason's got one.
Senator Mason.
Thank you, Madam Chair. The grasping at numbers around here always makes me a little crazy. How we pick 25, 50, 150. Is that based on anything other than the way we used to do it, or?
Madam Chairman, Senator Mason, there are approximately 570 assisted living facilities in the state. And so when you break up 4 tiers, it would mean that 171 would be in the smallest tier, 180 would be in the next one, 184 in the third, and 35 in the largest. And what we found in our members, we had one member that's got a large assisted living facility and 2 little ones. The 2 little ones are able to get affordable insurance because you can aggregate all 3 together.
That's
And
right.
so that's why we wanted to work the tiers.
That makes perfect sense.
And
Senator
it would be my hope that, when the board looks at this, that there ain't going to be anybody who is required to get less than $250,000 worth of liability insurance. And
And that's the reality, yeah.
that would be my sincere hope. Scott?
Mr. Johnson, I think Senator Servo.
Scott, are any of these, any of the 350 you mentioned, are any of them 501c3s?
I believe some are, but I can't quote you a number.
Senator Servo.
Because our membership spans for-profit, not-for-profit, and governmental, but I can't quote you exact numbers.
Well, further question is, do you have any idea whether any of them you try to utilize charitable immunity to avoid liability if they have insurance?
I have not seen that reported to us as an association or in the Lawyers Weekly or anything like that.
Okay, all right. Is there anybody in the audience wishing to speak in favor of the bill? Come forward.
Hi, Madam Chairman, members of the committee, Becky Bowers Lanier with Leading Age, and we represent not-for-profit homes for the aging. And I was asked to bring this forward. I hope you don't ask me any questions that you've asked Mr. Johnson, but we do support the bill.
Okay, all right, very good. Anybody wishing to speak in opposition? Hold on, colleagues. We have a hearing process. Senator Reeves.
My mic doesn't work. Mark, how many out of that 500 and some odd actually have general liability insurance right now?
I have no idea. I would imagine that the vast majority, but when we sought we couldn't figure out on that case whether they had liability insurance. They wouldn't tell us. We sought the licensure file, and they're like, I don't know. We hope that this creates a box in the licensure files for them to check saying, they do have it. So I don't know that we know. Do you, Scott?
Mr. Chairman, Senator Reeves, the DSS form today, they've actually bumped the number since Senator Obenshain's case. The number is 500,000. So a prospective resident coming in, you've got a checkbox form. You either say, yes, I've got coverage of at least 500,000 per occurrence in aggregate, or no, I don't. But I can't tell you how many do not have any insurance today.
I think this is a good idea. I will ask the clerk, is there anybody on Zoom wishing to speak, either pro or con, and it's all I want to hear is you're either in favor or you're in opposition.
Anyone on Zoom who would like to speak on the bill, you may raise your hand. We have no speakers, Madam Chair.
Thank you. I am now ready for a motion, colleagues.
Second.
Okay, clerk, please open the roll.
Ayes 13, noes 0, 1 abstention.
Okay, Senator Obenshain, now we're gonna hear the one that may have more robust comment.
Senate Bill 1242. This is bill dealing with geriatric parole.
Before you start, I just have a technical question. I do believe we can be heard on Zoom. Are our mics working? Is my mic working?
Testing.
All mics muted. There.
There we go. Wow, how did that happen? Are we better?
I was hoping everybody in the cyber world would hear that last one.
My apologies, I didn't know
Maybe they heard
that
me.
was even on. Okay, go ahead, Senator Obenshain. Senate Bill 1242.
Madam Chair, members of the committee, Senate Bill 1242 deals with geriatric parole. It is purely procedural, and I think that it largely codifies practice that has gone back for about 40 years. When somebody petitions for geriatric parole, it typically is heard when they're eligible. The parole board has the option to say that we are going to defer another hearing if it's denied for 3 years. And that has been their practice to do that in appropriate cases. It has not always been the case, but the reason for doing that is multiple. One is in inappropriate cases where parole is clearly inappropriate. In one of these cases, they can put it off for 3 years to reduce the workload, but more importantly than that, it reduces the angst, anxiety, and trauma to victims and victims' families who are notified and come participate in this process. In full disclosure, while I say that this has been the practice for 40 years, it was the practice for 40 years with the exception of the Adrienne Bennett chairmanship. She was pulling these back every year, and victims and victims' families were re-traumatized. So, Madam Chair, members of the committee, as I said, this is not mandatory. It gives the parole board the authority to defer for up to 3 years, and under Democratic governors and Republican governors alike, this has been the historical practice.
Just curious, do you know how many times the boards have decided to defer up to the 3-year period?
I don't, but I may be able to phone a friend.
I'm just curious.
Good
Yes.
morning, Madam Chair, committee members. Brandon Robleski, Special Assistant to the Attorney General. The 3-year deferral provision is already a law for discretionary parolees, which is the larger segment of the Virginia Parole Board's eligible population, and that's regularly exercised in cases in which parole is not granted for serious or lengthier sentences, and discretionary parole cases are regularly deferred for 3 years. So this just simply puts geriatric conditional release on the same footing.
Do you know?
But these
I do not have a number. It's a significant number of serious violent offenses with lengthy sentences that are regularly deferred for 3 years, but I apologize, I don't have the exact
But these
statistics.
offenders are much older, so a 3-year deferral when you're at 65 or, yes.
Well, it may be 60,
60.
and I take exception to the notion that 60 is very old, having just turned 60. I hope it's not.
Could be older than 60, so let's just be clear. Okay, because it's 60 or older, I believe is how the statute reads. Let's see if there are any other commenters. Anybody in the audience wishing to speak in favor? Anybody wishing to speak in opposition? Yes, sir.
Madam Chair, the Attorney General does support the bill. I would give an example of an individual who was age 65, who was up for his first geriatric conditional release hearing, and he was granted geriatric release by the Adrienne Bennett Parole Board. He was on probation for burglary, theft, forgery, and cocaine distribution. The man's name was James Turner. His most recent recidivism assessment showed a high overall risk of recidivism and a high risk of violent recidivism. This man was 65, and he was up for his first geriatric hearing. He had not completed any programs or education while incarcerated. The parole examiner recommended against releasing that gentleman, but the Adrian Bennett Parole Board released him anyway. So it's a situation that's happening not just in offenders who are extremely old or who have served lengthy sentences.
We understand. So
Madam Chairman.
Anybody?
Madam Chairman, can I have a
Yeah,
question?
sure.
please?
Senator Servell.
I'm sorry, I don't understand what that has to do with this bill. You said that you said this person got paroled. This has to do with reviewing people every year. What does that have to do with the purpose of this bill?
This individual was reviewed without a petition having been submitted. So this was a practice that was against the parole board's promulgated regulations of reviewing offenders who had not been submitting a petition under the Adrian Bennett Parole Board.
Madam Chairman.
Senator Servell.
Okay, I'm reading the bill. What does it have to do with the bill?
The bill requires the petition to be filed by the offender in order for the geriatric consideration to be.
Okay, tell me what line it says that on.
It says petitions on line 17.
Line 17, the parole board shall review, I'm sorry, Madam Chair, Senator Servell, I apologize. The parole board shall review annually all petitions for conditional release submitted pursuant to subsection A. So the practice has not been to review upon submission of a petition. It's just been to review anybody who is eligible. And that is not consistent with the promulgated regulations of the parole board. That was the practice of the Adrian Bennett Parole Board.
Okay, Madam Chair, further questions?
Senator Servell.
Okay, listen, when I read this bill, the way I read it, it has a bunch of mays in it. And so I didn't really see it as changing any policy because it just said they may review every 3 years if they feel like it or not.
Right.
But what you're telling me is that this changes policy by saying that a geriatric parole can only be reviewed if somebody files a petition. So that, for example, if we have another pandemic, a whole bunch of these older prisoners are going to be forced to file petitions before they can be considered if we want to try and get them out in case they might die, right?
Madam Chair, Senator Servell, that is how it worked during the pandemic. Petitions were still being submitted and offenders were still being considered.
Madam Chairman.
Senator Servell.
You're not answering my question. I understand what you think happened during whatever the pandemic, but my question was that if we have another pandemic and we have a very risky health situation for a bunch of old people that are medically vulnerable in jail, the only way they will be able to be considered for release is if every one of them files a petition. Is that right?
So, Madam Chair, Senator Servell, that would seem to be the case, but we had instances of the parole board not following its own written policy under Adrian Bennett. And so this codifies historical practice.
Okay, I think we understand the bill. Is there anybody on Zoom who wishes to speak either in favor or in opposition?
Anyone on Zoom who would like to speak on the bill, you may raise your hand. We have no speakers, Madam Chair.
Okay. All right, colleagues, the discussion is now with the committee. I will entertain a motion. Substitute? Okay. Substitute motion takes precedence. All those, okay. Will the clerk please open the roll? The motion is to PBI. You vote green if you're in favor of the PBI.
Ayes 8, no 6.
Madam Chair, any day I'm batting 500's a good day, so I thank you for your time and attention.
Thank you, Senator Obenshain.
Thank you.
Okay, Senator Mason.
Madam Chair, we start with Senate Bill 1508.
Excuse me. So today, assisted living facilities can be granted a provisional license to operate for 6 months because of a variety of issues, supply chain matters, but workforce, even in some cases, the ability to find and hire an executive director. They're bumping up against the 6-month period and risking going out of business because DSS cannot grant them any further timeline by code. So this just asks us to extend that to 1 year, 12 months instead of 6 months to make sure we get things in order and give them a little more flexibility and time. And that's the bill, Madam Chair.
That's it?
That's it.
Okay.
It's a good 8:30 a.m. bill.
You changed the 6 to 12.
Adrian Bennett has nothing to do with it, man.
Okay, all right. Is there anybody who wishes to speak in favor of this bill? Please come forward.
Good morning, Madam Chair, members
Good
of the
morning.
committee. My name is Judy Hackler. I'm with the Virginia Assisted Living Association, consulting with DSS as well as the assisted living providers. We support this bill, and it is precedent in DBHDS code as well.
Very good. Anybody in opposition? Anybody on Zoom who wishes to vote, who wishes to say either yes or no in support?
We have no speakers, Madam Chair.
Thank you. Okay, colleagues, I'm now ready for a motion. The motion, second, clerk, please open the roll.
Somebody got Mamie?
All right, your bill report, Senator Mason.
Wait a minute now.
I think Senator
Ayes
Mason.
Whoa.
Senator Mason, I think you want to vote aye.
There's one loser in every crowd, isn't it, Madam Chair? Did I press nay?
Do we have to strike the board and?
Todd, do we
or
have to
can we
revoke
just
your Freshman of the
annotate?
Year award?
You annotated his vote?
Good grief.
Okay.
Trying to
colleagues,
take Senator
we're gonna-
Rouse's moniker,
We're going to
man.
vote one more time. On the motion to report Senate Bill 1508, clerk, please open the roll.
Top down. Green? Oh, it's green. Thank you.
Why don't you just do it one more time so we have a picture of it? Oh, you don't know if you can?
Oh, goodness.
Oh, yes. Okay, all those in favor of reconsidering the last vote, please, I think we have to go on the board for reconsideration.
Oh,
Please open the rolls.
my apologies, Madam Chair.
Okay, that's okay.
Ayes
Yeah.
14, no 0.
Okay.
I'm working top down.
So, okay, very good. Please open the roll. On motion to support. Okay.
Ayes 14, no 0.
Oh, thank you, Madam
Okay,
Chair.
that's great.
That one went so well, Madam Chair. Let's go with Senate Bill 1513, and I
Let's try
believe
that
there's
again. Okay.
amendment. Is there amendment, Mr. Mayor, or substitute? Amendment. One line amendment, please, ma'am. So I get,
Sure.
while we find
So
it.
Mr. May will be.
The,
reading
this just adds the Commissioner of DARS to the State Council of, State Executive Council for Children's Services, largely because my local DSS rep is the chair of the State and Local Advisory Team, we call the SLAT, and there's no DARS rep on there. And so they're dealing with a lot of vocational coordination for youth in foster care, with special ed needs, with emotional, behavioral issues, and there's no one from DARS there to be a liaison. But I also just added, when Mr. May tells you about the line amendment, the Office of the Children's Ombudsman. So if y'all know Eric Reynolds, who's just doing phenomenal work, I feel like that whomever is in that role, if they can live up to what he's doing, would be a great person to have at the table for this discussion. And so that is a line amendment. When Mr. May reports it, I will move that amendment.
Okay, we'll ask Mr. May to read the line amendment, please.
Madam Chair, yeah, it's just one simple line amendment, line 20, after rehabilitative services, insert the Children's Ombudsman as defined in 2.2-438, and the Children's Ombudsman is the head of the Office of the Children's Ombudsman.
Okay. Second, all those in favor of accepting the amendment signify by saying aye.
Aye.
Okay, the amended version is before us. It's been explained. Is anybody in the audience wishing to speak in favor? Is anybody wishing to speak in opposition? Anybody on the Zoom world wishing to speak in favor? Anybody in opposition?
We have one speaker, Madam Chair.
Go ahead, let the speaker in.
Ms. Milling, you may provide your testimony.
Hi, yes, this is Tanya Milling with the Arc of Virginia. We very much support this bill because of their role in supporting students as they transition out of school. DARS is a really key partner to improve coordination, and we thank the patron and support this bill. Thank you.
Okay, a motion has been made and seconded. Will the clerk please open the roll? This is a motion to report as amended. Okay.
Ayes 14, no 0.
Ayes Ayes 14, no 0.
Thank you, Madam Chair, members of the committee.
Senator Mason, your bill reports. Okay. I am going to ask David May to present the second bill that Senator Deeds had, and I believe it's Senate Bill 1299. At Senator Deeds' request, he is tied up, so Mr. May is going to present the bill. And there is a substitute.
Or somebody else.
No, we referred 1379 to judiciary. You're listening to 1299. Yikes. Okay, Mr. May, go ahead.
Madam Chair, with the permission of Senator Deeds, I just offered his substitute online so you can see it. The general spirit of the bill is the same. It just does some cleanup, and it really does two things. Let me turn to the correct page here. We put a technical kind of cross-reference to our new language in section 37.2-809, and the meat of the bill is really in starting on line 148 and 37.2-813. And what it provides is that if a person is subject to a temporary detention order and they're awaiting transport to the facility of temporary detention, the director of the facility where they are awaiting transport can release the person if certain criteria is met. And that criteria would be that an employee or a designee of the local community services board, which is a defined term for release processes that already exist, in consultation with the person's treating physician, conducts an evaluation of the person, determines that they no longer meet the commitment criteria for the TDO, authorizes the release of the person, and provides a discharge plan. So the director of the facility would not be the person making the decision. It would essentially be the representative from the CSB, and that's all the bill does.
Move the substitute.
Great, the substitute has been moved and seconded. All those in favor signify by saying aye. Aye. Okay. Substitute's adopted, and I really like the substitute. Tightened up the definition of facility director. I think it's now doable. And I believe, okay, there's no fiscal impact. Is there anybody who wishes to speak in favor of this bill? Please step forward.
Thank you, Madam Chair and members of the committee. My name is Claire Hackton, and I'm a student at the University of Virginia School of Law in the State and Local Government Policy Clinic under the supervision of Professor Andy Block. I've worked with Senator Deeds in drafting SB 1299. The views I express today are my own and do not reflect those of the university or the law school. I'm here today to ask you to pass SB 1299 and to share why it will help reduce state hospital overcrowding, support patient liberty, and reduce burdens on law enforcement. Current law gives authority to the directors of psychiatric facilities to release individuals under TDOs if they no longer meet criteria for involuntary commitment. SB 1299 expands this authority to hospitals where an individual under a TDO is present prior to transport to a psychiatric facility. This change is important because many individuals under TDOs first wind up in emergency departments. Many of them improve during the time they spend there such that they no longer meet commitment criteria, but hospitals do not currently have authority to discharge them. SB 1299 allows hospitals to discharge these individuals if an employee of the Community Services Board determines that they no longer meet commitment criteria. In doing so, SB 1299 will free up valuable beds in state facilities by allowing hospitals to discharge individuals awaiting transfer to these facilities. Second, it prioritizes patient liberty by sparing individuals the trauma of being transported to a psychiatric facility, which is often far from their home, just to be discharged upon arrival. And finally, SB 1299 provides that when an individual under a TDO is released pursuant to its provisions, that law enforcement is relieved from custody. This frees up law enforcement for more important obligations. For all these reasons, I urge you to vote for SB 1299. And I would just like to add that the Sheriff's Association does have a slight amendment that just changes the language from persons awaiting transfer to the facility of temporary detention to persons present prior to transfer to the facility of temporary detention. So that is just a small thing. That's language that they've requested.
Is that language that Senator Deeds agrees with and would
Yes.
like to present?
Yes,
Okay,
Madam Chair.
Could you please?
Move the amendment.
Okay. So the amendment has been made and seconded. So we've amended the substitute. the committee believes that that's a reasonable amendment. This is a much improved bill. Okay, anybody else wishing to speak in favor? Dr. Block, do you want to speak in favor? Okay, anybody in opposition? Anybody on Zoom?
We have one speaker, Madam Chair.
Please let the speaker in.
Suzanne Mayo, you may provide your testimony.
Good morning. My name is Suzanne Mayo. I'm with the Virginia Department of Behavioral Health and Developmental Services, and I wanted to share that we support this bill.
Great, thank you so much. Okay, colleagues. Okay, we're reporting the substitute as amended. Clerk, please open the roll.
Ayes 14, no 0.
Well, we could tell Senator Deeds his bill reports unanimously.
Madam Chair.
Thank you for your work on this. It's very important.
Thank you.
Okay, I guess I'm the only one left. Senator Lucas is not here. All right, I'm going to present, and then if Senator Lucas doesn't make it, maybe Senator Servo, I'll have you present on her behalf since you did do the amendment. But I'll go first. It's possible she might get here. Senator Servo, do you want to? Do you want to sit in the chair seat? Okay.
It's a Senate Bill 1267, Senator Favola.
It is, thank you. So this is a bill that comes to you from the Behavioral Health Commission, and it is very simple. It does two things. It requires that each community service board in the Commonwealth develop and regularly update information on the services they provide, and to make this information available to their courts. So it would be the JDR court, the General District Court, and the Circuit Court. And then it also makes sure that in the various courts, individuals who were not found guilty when evidence was introduced that provided documentation of a mental condition, that this information be provided to the defendant so that defendant can access services. So that's the bill. We're trying to close the gap in cases where we know an individual had presented evidence, there was a mental illness of some type, has a cause for the allegation on the offense, and if they're found not guilty, we want them to be able to get services through the Community Services Board. So that's the bill.
Any questions to the patron? Senator Boysko.
Thank you. Can you clarify, Madam Chair, that an individual would not be forced against their will to?
An individual would not be
forced. So this provides information, it is permissive.
Provides information and, yeah.
Thank you.
Sure.
Any other questions to the patron?
Mr. Chair, I have a question.
Senator Rouse.
Thank you. Senator Favola? Mr. Chair.
Senator Rouse.
Yes. Who will be the keeper of these records? Oftentimes, on the local level, I've heard from our courts that the keeping of records is a very strenuous process. So I'm just wondering.
Well, if the CSB has to share the information, there's a clerk of the court position. It's a constitutional officer position, and so information would be kept there. Does that make sense?
I guess
Senator Rouse.
Thank you, Mr. Chair. Is there a budget requirement associated with this or no?
I don't have a fiscal requirement, so there's not a state. Our budget our fiscal impacts deal with state fiscal impacts. There's not a fiscal impact on this bill.
Okay.
Senator DeStefano.
Senator DeStefano.
There actually is, but the department can absorb it.
Okay.
I hold my statement.
Senator Rouse,
There's not a fiscal impact. There's not
There you go.
There's not a new fiscal impact.
Thank you. Mr.
Any other questions to the patron?
Mr. Chair.
Senator Rouse.
Thank you. Just a lot of times at the local level, we get courts coming to city council asking for more funds to be able to maintain records and such. So I just wanted to make sure that we wasn't giving more burden to the courts on that, or what was the fiscal impact?
We haven't received any comments to that effect. So we're expecting that this is something that can easily be absorbed and not a significant burden of any type on the locality. But I appreciate your local perspective. So,
thank you.
Sure, thank you.
Senator Mason.
So, Mr. Chairman, we are going to see more and more and more of these bills where someone was found not guilty, and we're trying to figure out how to help them along. I got executed by you and others in judiciary the other day on a not guilty situation, and we just need to make sure we're mindful of the fact that we're really trying to make sure people are not criminally convicted, but it doesn't forego their need for treatment and health and our ability to categorize their needs. And so we're going to see more and more of this. It's not an effort to continue to go after people or do something to them once they're found not guilty. It's our effort to find them criminally not guilty and then still help them. So
We want to keep them out of that intersection with the criminal justice system. So if they're not offered treatment, they're likely to come back through the court system. So this is really something that's needed. And again, the Behavioral Health Commission spent many hours listening to testimony, and Sarah Stanton, of course you know, who once worked with us in DLS, is our policy director for the Behavioral Health Commission. So
move to report.
Question about, hold on, we got to take some testimony too. Who said that? Somebody had a question. Oh, Senator McPike.
Yeah, Mr. Chair, a question for the patron in terms of, I see JDR listed, I see Circuit Court, but I don't see General District Court.
General
Why
District
no
Court is
GDC?
there. At least I have it down here. It's like, okay, is there a note here? Okay. I have General District Court listed on line 38. Sure, go ahead.
Thank you.
Ms. Stanton, you got to answer the question.
Yes, Senator Fuller, there's a technical line amendment that needs to be made to the bill.
Yeah, I can see
And
that.
we'd had it 2 weeks ago, but I think it got lost in our shuffle. On line 19, after trial in A, you would strike juvenile and domestic relations and insert general, so that it would be clear that that first section in the bill refers to the general district courts and ties up the process of making sure that that information is.
Senator McPike,
Thank you.
it's been moved and seconded that we make that amendment. All those in favor say aye.
Aye.
All those opposed, no. The amendment's adopted. Good catch, Senator McPike. Yeah.
Thank you for catching that.
Okay, are there any other questions to the patron before we move to public comment? No? Does anybody in the public have any comment in support of the bill? Is there anybody in opposition to the bill? We got anybody in the Zoom room?
Anyone on Zoom who would like to speak, you may raise your hand. We do not have any speakers, Mr. Chair.
Okay. Is there a second? It's been moved and seconded that we report the bill. All those in favor, the clerk will open the roll.
Ayes 14, no 0.
Okay, so now we have Senator Lucas's bill, and Senator Sergel is going to present for her.
Yeah, I have there's an amendment to that. I move the amendment.
All those in favor signify by saying aye. Okay, amendment's made and seconded. Okay. Senate Bill 1214.
Thank you, Madam
Go
Chairman.
ahead.
We heard this bill last week, and Senator McDougal and I noted that there was the standard that was set forth in the bill did not seem to recognize Virginia's longstanding policy of decisions being or requiring to be made in the best interest of children. And so I prepared some language, worked with the Family Law Coalition to come up with language that incorporates that standard into the concept we're trying to do in this bill. And that's basically what the amendment does. I think the bill was otherwise in pretty good shape, except for that one little point.
And Madam Chair, I believe the motion would have needed to be, because I saw the amendment, but it reloaded as a substitute, so it'd be to adopt the substitute.
Okay, all those in favor of adopting the substitute signify by saying aye. Aye. Okay, so this includes the amendment that we had discussed, as I understand it. Is that correct, Mr. May?
Madam Chair, that's correct.
Okay, so we've got the complete bill before us in possession, consumption of, okay, I don't have any
I think it's on line
questions.
293, I think is the new language. Yeah. Yeah, so it basically says possession or consumption of the substances, and also, I'm sorry, it does two things. One is it incorporates the best interest of the children standard, but also it treats the consumption of all legal substances the same. Her prior language did not also talk about alcohol consumption, it only talked about marijuana, and so by framing it as title, any substance authorized to be consumed under Title 4.1, it picks up both, treats them the same.
Okay. Anybody wishing to speak in favor of the bill? Anybody wishing to speak in opposition? Okay, wait. This woman's coming forward, and I am going to have to ask about Zoom. We are in a public hearing. We appreciate the public commenting. We are doing the public's business. Please come forward.
Yes, my name is Chelsea Hicks-Wise, Executive Director of Marijuana Justice. I just want to say thank you. We support this bill, and thank you for the amendment cleanup.
Thank you.
Madam Chair and members of the committee, I'm Tamara Netzel, representing Cruel Consequences of a 501c3 nonprofit that helps others tell their own stories of the human cost of marijuana prohibition. Thank you, Senator Lucas, for writing SB 1214. Thank you. This is Edward. He lost custody of his children because he's a medical cannabis patient. There are thousands of Virginians, parents who have stories just like his, and this is just one of the cruel consequences of marijuana prohibition, and we hope that you advance the bill.
Thank you. Is there anybody in the Zoom world that wishes to speak either in favor or in opposition to the bill?
Anyone on Zoom who would like to speak, you may raise your hand.
Okay, I just thought maybe I'd stand since I had to run from the 14th floor.
Is there anybody in Zoom?
We have no speakers, Madam Chair.
Okay, so you may have the final word, Senator Lucas. It's a very good bill. Senator Serval did a good job presenting.
Well, I thank you.
We understand it, and you're on a roll.
Well, then I would just keep quiet for a change.
Suck up. Motion has been made and seconded to report the substitute. Clerk, please open the roll.
Thank you, Madam Chair, members of the committee. Thank you. Now I can sit and catch my breath.
Thank you. Okay, so 19 to 4, is that where we are? At 9 to. Okay, according to my notes, I have nothing else on the docket, but I will ask Mr. May, have we completed our docket?
Yes, Madam Chair.
There's nothing further for the committee? Okay, hearing nothing else, the committee shall rise.